Hi everyone, in this week's video we're going to be focusing on part-time workers and specifically avoiding the risk of a discrimination claim arising from the protection that they have. Now, in determining whether a worker has been treated less favourably than a full-time comparator, and thus in order to prove a discrimination claim, a pro-rata principle must be applied, and the focus of this video is on how we apply a pro-rata principle. That derives from the part-time worker regulations. The most simple example of this is annual leave. So if a full-time worker is given 30 days holiday, somebody working 3 days per week rather than 5 will receive 3/5 of that holiday entitlement. So tribunals recognise that a part-time worker should, as far as possible, receive a pro-rated entitlement to pay, benefits, other terms and conditions as far as possible. Now, that pro-rata principle must be applied unless it is inappropriate, and we'll come on to the difficulty in identifying what might be inappropriate. But there is a general difficulty as well in applying certain benefits. So what if a business provides a company car to sales employees and we have one employee who works 3/4 of a full-timer's entitlement? We can't provide 3/4 of a car or 3 wheels on a car. So a more creative solution generally has to be adopted in that position. The part-time worker may be provided with a less expensive car, or a pro-rated cash equivalent may be paid as an alternative. I should say that many businesses in these circumstances just accept that certain benefits can't be pro-rated down and the benefit will be provided. There is no comparable discrimination claim from a full-time worker to suggest that they've been treated less favourably than someone who is part-time. Another interesting example is healthcare benefits. So these premiums tend to be paid on an annual basis for things like private health or life assurance, and they don't bear any relation to the number of hours worked or the length of the contract. Again, getting creative, some employers will say that they will pay a proportion of that premium that relates to the proportion of working time that the employee is contracted to. Or they might, again, simply allow full access to those benefits irrespective of the hours that they work. So we'll now look at car allowance. That's an interesting one because that's an example where there's no real case law to support the position. But is this the case where pro-rata principle is appropriate or is it inappropriate? The employee may argue that a pro-rata principle should not be applied to a car allowance. The purpose of the allowance is to compensate an employee for having to use their own car, having to tax, insure it, account for depreciation, provide for repairs on that vehicle, and that will be incurred whether or not the employee works full-time or part-time. So there is a question mark about whether it would be inappropriate to reduce the value of a car allowance or on those occasions simply because somebody works part-time. I think that will be a general negotiation point for a recruitment exercise. If somebody went from full-time hours to part-time, making a flexible working request, it would be interesting to see what decision employers come to. My view is that it would be appropriate to pro-rata to the entitlement because someone will not be using the vehicle for the same amount of time as a full-timer who has a car allowance as well. The final thing I wanted to talk about was overtime, and an interesting decision which is applied in the European Court of Justice, and that is that part-time workers are not considered to be treated less favourably in respect of overtime if they are entitled to overtime rates once they've worked the same total as a full-time worker. So that might not be the most simplistic explanation I've given, but if you take a full-timer working 40 hours, for example, their contract states that overtime rates kick in at 1.5 times the hourly rate after 40 hours have been worked. If we then compare that with a part-time employee working 20 hours, the European Court of Justice have said it's absolutely permissible to require that part-time worker to reach 40 hours of work before any enhanced overtime rates apply. The part-time worker may argue that they should receive enhanced overtime rates after 20 hours, but the Court of Justice has disagreed with that, and I do think that's an interesting decision because it does depart a little bit more from the general rules. Many employers do overlook the effect that decisions have on part-time employees. And it is important to understand that whilst there is a pro-rata principle, there is a route of direct and indirect discrimination claims that can be brought by part-time employees. If you do need any further support on this, or indeed any other employment matter generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.